Our next presenter has plenty of first-hand experience of what happens when parents do not follow the biblical truth of spare the rod, spoil the child. A practicing attorney who specializes in civil litigation and Second Amendment cases, this man is double trouble for the Democrats because he serves his hometown of Wallingford as both a town councilor and as a state representative of the 90th District, which also includes Middlefield. Here to discuss the state of our state's juvenile justice system, please give a big hand to the indefatigable Craig Fishbein.
Thank you, everyone. I think Annie did a great job.
Yeah, she did. Yes.
If I knew what Annie was going to talk about today, I probably would have talked about other stuff here today. War stories are always good in the legislature. I'm happy to be one of the hateful eight. It's been an honor to be in the legislature. Two of the principles that this group, are guided by, number one, life, liberty, and the pursuit of happiness. Your freedom actually begins with your arm and ends with your fist at your neighbor's cheek. That is the extent of your freedom. Individual liberty is prong number one. Prong number 11 is victim rights. And unfortunately, in our state, victims are not really protected. So what I'm going to, a lot of people talk about how did we get here? A lot of people don't know a lot about the laws, the changes to the laws, that kind of stuff. So I thought today that I would bring a level of education to show you some statistics, how the laws have changed, some proposals as we go into our next legislative session. So no poems today. Coming from Chris Healy, yeah. But we're going to talk about juvenile justice. So, we see it every day in our newspapers all across the state, articles in the news, kids stealing cars, kids dying in stolen cars. It's a problem. So we're going to talk about here today, I'm going to give you our agenda. We're going to look at some data. We're going to look at some of the reforms that have been done since 2010. Such things as determining when a child is a juvenile. When can a court order a child detained? When can a case be transferred from the juvenile court to the adult court? Some other reforms. What options do the police officers have when they come to find a child? They may think that the child has committed a crime. Some upcoming bad proposed reforms. Some upcoming good proposed reforms. And I'm going to leave you with some hope. Okay? And I come to you not only am I a member of the Regulations Review Committee, which is a very unique committee in the legislature. A lot of people don't know how regulations are created, but every committee of the legislature, except for Regs Review, is dominated or it's apportioned in line with how the legislative branches, the House and Senate are apportioned, right? So like on the Judiciary Committee, we have 45 members, only 12 of them are Republicans, okay? So it's like a 1/3, 2/3. Every other committee, except for Regs Review, is set up in that sort of apportionment. Regs Review, though, is 14 members. It is 7 Republicans, 7 Democrats. And it's actually co-chaired by a Republican and a Democrat. So a very unique committee. They're the ones that actually do regulations in the state. That's one committee that I'm on. I'm also on the Public Safety Committee, and I'm the ranking member of the Judiciary Committee, which means that I'm the highest, I lead the Republican caucus from the House of the Judiciary Committee. Okay, so And Annie is ranking on children, just to put things into perspective, okay? So, what does the data show? This is a chart, and it's hard to put all these stats together, you know, all of the data doesn't come in at the same time, okay? But this is a graph that you'll see the Democrats rely upon to say that crime in Connecticut is down, okay? The upper line is the national average. The lower line is Connecticut, so obviously the lower line is going down. But the problem is that this is violent crime. Murder, rape, you know, assault, those kinds of things, right? So cherry picking, okay? This is property crime, okay? And I want you to center on that rise at the bottom, okay? 2019 through 2020, there was an increase. So that's like into the pandemic area, okay? Dramatic increase, while the rest of the country is going down, right? The data is from the FBI. So looking at motor vehicle theft solely, this is comparing adults to children, okay? The top line is adults. The bottom line is juveniles, okay? So you see the inverse, right? So let's unpack some of that data. In 2010, which we're going to put a pin in 2010, there were 667 arrests for motor vehicle theft. 143 of those were of juveniles. 6 years later, once some of these reforms start to play out, which we're going to look at some of those reforms, obviously the arrests have increased to 852. 28% increase. But look at the kids. 278 of those arrests were juveniles, right? Almost 100% increase. 2018, 2 years later, total arrests go down, 21% increase from 2010, but the increase in juveniles getting arrested for stealing cars. 2020, basically the same in the arrests in 2010. Slight decrease with juveniles, okay, 70% compared to 2010. 2023, 850 arrests for motor vehicle theft, 28% increase in 2010. Kids, 270% increase in 2010. Straight data from the government. This is a chart, and once again, it's hard to get all of these numbers. But what I want you to focus on here are a couple of things. First of all, the dramatic increase that's shown in the bottom, the top line being the national average, the blue line being Connecticut. 2019 through 2021, Connecticut was 4 times the national average in motor vehicle theft. I don't hear any Democrats talking about that, right? So then I want you to look at the fourth column, which I know it's hard to see in the back, but I'm going to tell you that fourth column is what's known as the clearance rate. Okay, clearance rate is an officer identifies a perpetrator, arrests an individual, case is disposed of through the court. Okay, whether diversionary program or eviction or whatever. Clearance rate, right? So in 2010, the clearance rate was 9.21%, okay? And then it goes up to a height, 2017, of 12.09%. But in 2020, the clearance rate, 2020, goes the lowest it's been in over a decade, 7.3%, okay? And if you think about 2020, what happened in 2020? The police accountability bill was passed, which I'm not going to get into today, but, you know, just understand that's what I think it's a direct correlation. So the most recent data, in 2021, just looking at the I want to go back, looking at this is dealing with the total number So if we take the total number of incidents of motor vehicle theft, an investigation, clearance rate, applying that, right? In 2022, there were 6,284 motor vehicle thefts reported in Connecticut. For just the first 11 months of 2023, 8,384 motor vehicle thefts. The crime is down in Connecticut, right? We heard through the pandemic, well, kids have nothing else to do, they're going to steal cars, you know, it'll all work itself out. It's 2023, we're post-pandemic, right? Clearance rate for that period of time, 8.25%. Okay, still hasn't reached the 12%. So these are unsolved for the most part, motor vehicle thefts. Now I can't presume that just because a car was stolen that it was a kid. So I don't want to hyperbole here and say that a certain number was. Dealing with data and facts, right? These are the raw data, these are the numbers. Now motor vehicle theft is not a victimless crime. You know, they will say, you know, you'll hear, well, the insurance company will make the person whole, right? So, but they don't understand that when insurance companies pay out, premiums increase, right? So you are victimized as a result of that. Your car gets stolen and you're a senior citizen, you can't go to the pharmacy and get your prescriptions. You're a mom who's got kids at home, you normally drive to school. How are those kids getting to school? There are victims, actual touch victims of car theft. There's families that are victimized by car theft. So we have to permeate that culture, right? Because a lot of people in Hartford think that motor vehicle theft is a victimless crime, and it's not.
So such thing.
So we're going to look at some of these reforms since 2010. Well, the first thing that you have to figure out is when is a youngster a juvenile for the purposes of adjudication in a juvenile court? Well, originally, there was no minimum age to arrest a child. But then, I believe it started with 7. So under the age of 7, the youngster could not be arrested. There was no adjudication, okay? Then the minimum age was raised to 10 in 2021. And that's where we are presently, okay? So if a youngster under the age of 10 commits any crime in the state of Connecticut, they cannot be arrested. That is the law today. So then you have to deal with what's the maximum age for juvenile court. Prior to 2010, it was a person under the age of 16 for any offense. And then they started to expand it. After January 1, 2010, person under the age of 16 at the time of any offense, and they started to go 16-year-olds charged with certain offenses. We're going to take those and we're going to put those in juvenile court too. And it's important. You're going to see why it's important for a case to be in juvenile court as opposed to adult court. Because the possible penalties are very, very low in juvenile court. Okay? After July 1, 2012, it became a person under the age of 16 at the time of the commission of the offense, and started to expand it to 17-year-olds, okay, for juvenile court. So when can a case be transferred from juvenile court to adult court? Before 2012, children 14 age and older charged with certain felonies and arson and murder were automatically transferred to adult court. Those 14 and older with lower offenses, it was a discretion. You would apply, the prosecutor would apply to the court for the transfer, and the court could transfer the case to the adult court. But in 2021, the legislator added a portion saying that it had to be in the best interest of the child, not the victim, the child to transfer from the juvenile proceeding to adult court, Okay, so that got inserted in there. And in 2015, raised the minimum age for transfer from 14 to 15. So a 14-year-old who commits any crime in the state of Connecticut cannot be transferred to adult court. Okay? And shifted some of those severe felonies, the Class B felonies, to the discretionary statute. So an example of a Class B felony is assault with a firearm. It became discretionary to transfer from juvenile court to adult court. So here's a case, this happened in 2017, where 3 teens, they were 13, 14, and 16, blinded and maimed a 45-year-old delivery worker. Now, 2 of those young individuals could not be transferred to adult court because they were under the age of 15. The other one could be transferred to adult court. Okay? So when can a juvenile be detained? You know, just because somebody gets arrested doesn't mean they're going to be held, right? So we have standards for that also. Originally, there had to be probable cause they committed the crime. There was no less restrictive alternative available. And these are, you have to have all of these. And one of the following. Strong probability the child will run away. Now that's going to be in just certain crimes, right? So motor vehicle theft, there's no evidence that the child will run away. You know, so that means can't be held, basically. Strong probability they'll commit another crime, offenses to the child or to the community, okay? Probable cause to believe the continued residence in the home poses a risk to the child or the community because of the serious and dangerous nature. Need to hold the child for other jurisdiction. Child has failed to respond to the court process or the child has violated the conditions of release. That's where we started. But in 2016, which became effective in 2017, the legislature started to strip these things back and to make it more difficult to hold a child pending adjudication. Took out strong probability they'll try to run away. They violated the conditions of release, which I think is a very important one. So if a young man comes before a judge and the judge says, you know, don't get arrested again, or, you know, go to school, or something like that, and the kid doesn't go to school and they get arrested again, they can't be detained. Make any sense? No. Requirements to place a child in detention after 2000, or this became effective in 2018. Probable cause they committed the acts alike, and then the legislature added the word appropriate, which is subjective, right? What's appropriate to you is not necessarily appropriate to me. So added that as a requirement also, and started to look at the level of risk. So even though they could be of risk to harm to the community, then you had a balance to look at the level of risk to hold a young man in this particular situation. Need to hold them to assure their appearance before court, hold for another jurisdiction. Now, one of the problems that I recognized in 2021, we put together a group to meet with various stakeholders in this area, that an officer who arrests a child, let's just say for stealing a car, because of our sealing of these cases, an officer in the field would not have access to that youth's criminal history. Wouldn't know if they had been arrested the night before for stealing a different car, or, you know, was pending 4 other cases. Would only know about that particular case. So in August of 2021, the legislative branch agreed to start to allow officers to have access to more information, and that was very helpful. in detention orders and things like that. Detention orders in particular, because when an officer applies for a detention order to a judge, they're supposed to put on the piece of paper why they think that the judge should order the child held. But if the officer doesn't know this kid just got arrested, the week before for stealing 4 cars, that is material information that the officer should be imparting to the judge to make that determination. 2018, some other changes were put into place. Juveniles can't be held for more than 6 hours without an order from the judge to hold that person. Juvenile justice programs are transferred to DCF, from DCF to the judicial branch. And CJTS, which is the Connecticut Juvenile Training Training Center, was scheduled to close on June 30th, 2018, and that's where kids would go. They would be held pending adjudication of their case. But Governor Malloy actually closed it early in April of 2018. And as a result of that, we were left with really no place to hold these kids. And as a result of that, most committed juveniles were released home or put in non-lockdown staff security facilities. So, we hear about Connecticut Juvenile Training School, is what it's actually called. Some people denigrate this place. I just wanted to show you what this place looks like.
It's like a hike.
This is a typical residence quarters. This is the common area,
It's a training center.
library, gym. They had some employment, job training classes there too, a portion of which the greenhouse was used for. There's a classroom.
Better than my elementary school.
So it doesn't look like a prison, right? That place is closed right now. It's been closed since 2018, okay? Here's the dining area. Of course, they have security there, inside, outside. Then as we progressed, we had to deal with, the legislature took it upon themselves to deal with maximum sentences. Before 2018, the maximum commitment from a juvenile court case was 18 months with a possible extension of 18 months for a total of 36 months for non-serious charges and 4 years for serious charges. But after July 2018, it was changed. And they were given a list. They could be discharged with or without a warning, put on supervised probation or probation with residential placement for a total of 30 months, regardless of the severity of the charge. Okay, this happened in 2018. Post-2018, we had some other changes. In car theft cases, we created a diversionary program where on a first-time charge, a kid could apply for that case and the case would be dismissed. The legislature also tinkered with the holding of a child and made the judge make a finding that they had to pose a risk to public safety. We also created a charge of enticing a minor. The interesting thing about this, this was put in place to try and attack the Oliver Twist Fagin sort of situation where an adult is cajoling a youngster into stealing a car or something like that. But look at the gap in ages. So you had to be 23 years or older to be charged with this. The 19 through 22-year-olds cannot be charged with this. That was what got worked out in the legislature. I wanted a 19-year-old and higher. But of course, we know what's going on in Hartford. The minimum age for the arrest of a child was raised from 7 to 10 at that point in 2021. In 2022, we expanded and codified the ability of an officer to see the record in the field. And last year, we created this larceny of a motor vehicle charge, which I think is one of the most important things that we've done. Larceny, up until this time, stealing a car, the charge is based upon the value of the car, right? Not that it was a car. So a $5,000 car really has the same level of value to a person who has a $25,000 car, right? But they were charged differently because of the value of the vehicle. And I said, no, victims are impacted as a result of this. So we kept them all even. You steal a car, you are charged with stealing a car with a graduated offense, okay? First offense is one thing and then it gets higher, okay? Which is something I think a lot of us were asking for. One of the bad things that passed last year is, up until last year, it's been Supreme Court precedent, that an officer can lie to someone they are interrogating, which is an interrogation tactic that many of us use in our own homes, right? Right? With the kid, you find the broken vase, well, I saw you do it, or something like that, right? And then, they fess up, right? Officers cannot do that anymore with juveniles, okay? So that's one of the bad things. And then the judicial branch voluntarily put in a program to have next day arraignments for kids that are arrested for stealing cars, which I think was a good thing. So what options do police presently have with a juvenile they believe has committed a crime? Well, right now they can warn the child, take no further action. They can refer the child to a juvenile review board, which is usually community-based. They can charge the child with a crime, release the child to their own custody, and refer it to court. Charge the child with a crime, release the child to a responsible adult or agency, and refer it to court. Or arrest the child and obtain an order to bring the child to a juvenile detention center, which presently we have one in Bridgeport or Hartford, which is a problem, I'm going to tell you, and that's the reason why you may have seen in the news recently the judicial branch is looking to spend, I think it's $10 million, to reopen CJTS to use for this process. Because I don't want a kid who got arrested for stealing a car to be housed with somebody who's, sex assault or a murderer, something like that, right? It's just going to deteriorate these kids even more. So we have to have a separate facility, in my opinion. I want to give you a hypothetical case as I start to wrap up. You have a 12-year-old who's arrested for punching another 12-year-old in the face without provocation at school. A few months later, the 12-year-old is arrested for assaulting another child on a school bus. After punching the victim in the face, he gets on top of him, continuing to strike him. Youth turns 13, arrested for a domestic at mom's residence. After he hits mom in the face, spits on her, slaps her, pulls her hair, he then grabs a knife and threatens to kill everyone in the home. Youth turns 14 and is arrested after officers respond to a report he was throwing knives at other family members. That started because the grandmother questioned him about a bullet hole in his wall. A month later, the 14-year-old is a suspect in the investigation of a non-fatal shooting. And a few weeks later, as a result of a separate incident, the 14-year-old was arrested for murder. That's the hypothetical case that I'm going to present to you. So let's dispose of those facts. Well, because the accused is under 18, he comes to juvenile court. Because he's under 15, the case cannot be transferred to adult court. If he's convicted of the murder, as well as any of the other crimes, the maximum penalty that he can serve is 30 months of supervised probation, with or without residential placement. He's probably going to get residential placement. For 30 months, okay, on murder and other stuff. At the age of 22, so 4 years after becoming an adult, he can apply to the juvenile court to erase his record. And that erasure is not discretionary. It is mandatory. How do you explain that to a grieving family? That is the state of the law in Connecticut based upon all of those changes since 2010. And it's not a hypothetical. That young man was arrested last year. That is a case that is currently pending in the state of Connecticut. So I want to tell you about some proposed reforms. We have some bad proposed reforms that you're going to hear about this coming legislative session. They want to raise the age gap. They want to make it that a 15-year-old and younger cannot be arrested for any crime in Connecticut. I just read an article a few weeks ago. A young man in Texas, 13 years old, stabbed his mother to death. You know, even under our law today, you know, look at the 13-year-old and whether or not they can be arrested. That case is going to go to juvenile court if it was here. But here, 13-year-old would not be able to be arrested for anything. That a child 17, well, we had this just last legislative session. We had this bill, and this bill made it out of committee. All the Republicans voted against, all the Democrats voted for it. That a 17-year-old cannot be arrested for simple trespass, larceny 6, creating public disturbance, and disorderly conduct. But they didn't know that, well, they should know by now that I read everything, okay? And I'm going to... Thank you, Dad. I'm going to tell you, what they really wanted here was the larceny 6. And the reason why I knew that, well, and probably disorderly also, is a simple trespass. You don't arrest kids, you don't arrest adults for simple trespass, okay? You give them a ticket, they go on their way. So when they were saying can't arrest for simple trespass, we don't arrest, it was a misnomer, right? We're going to leave larceny 6 away for a little bit. Creating public disturbance, same thing, it's a ticket, go on with your day, okay? So they weren't really, so they were focused, if anything, on the other two. Larceny 6 is stealing up to $500, okay? So, kid could not be arrested for stealing up to $500. It would have to be reviewed sent to your juvenile review board in your local community. But juvenile review boards, it takes about 45 days to get them up and running on that particular crime and that kind of stuff. So I asked them during the public hearing, I said, if the kid does it on day 1, steals $500, they can't be arrested for juvenile review board. What if they do it on day 2, and day 3, and day 4, and day 5, and they admitted that this kid could steal $500 a day and not be arrested, okay? The other thing is that larceny in the 6th is extortion also. So, kid calls up grandma, you know, unless you give me $499, I'm going to harm your grandson. Couldn't be arrested, okay? So let's look at disorderly. Disorderly conduct is fighting. A 17-year-old gets into a fight at school, something like that, would not be able to be arrested, okay? We were able to kill that, but it's coming back. This risk assessment tool, you're going to see that also, and that will be a series of questions that when a case is in juvenile court, they ask the young man, not to go after boys today, but you know, a series of questions. They'll score it, and if it scores at a certain level, the case goes back to the town. Now, if the town says to the kid, "Don't get arrested again," and he gets arrested again, they can't violate. It's not reciprocal. It can't go back to the criminal court. This risk assessment tool it will be a problem. They're going to be looking to abolish cash bond for all juvenile arrests. The argument being, kids don't work. You know, a 15-year-old, they don't have a job. You're just imperiling the parent. You're making the parent. Maybe that's a good thing, but that's another thing you're going to see. So that's some of the bad stuff. So some good proposed reforms you're going to see. GPS monitoring. We need to get a more robust GPS monitoring for these kids that are arrested and then they get arrested again. Gangs don't like to deal with kids that have ankle bracelets. Okay? So we need to work with that. Close up that gap on the 18 to 23-year-olds on enticing a minor. There's no reason why a 19-year-old can't be arrested for violating that. Do you know that right now, if a kid stole a car from this parking lot, and they were from, let's say, Hartford, the case is not going to get adjudicated in New Britain, which is the jurisdiction that does this particular area. The case is going to Hartford. Now, cases are adjudicated where the youngster is from, resides, not where the event happened. Now, that impacts victims, right? It makes it more difficult for them to go to court. It also victimizes law enforcement because many times they got to go testify in that particular case, and they're coming out of their jurisdiction, even though the crime was created in their jurisdiction. So, we'd like to reverse that. Require all auto theft cases to be automatic transfers. CJTS, I've already talked about. We need to do something with the 6-hour time limit to hold the child. If the officer applies for a detention order and the judge hasn't been able to turn it around, that should flex. You can't have just having to release kids just because that's 6 hours. Have a judge, upon denying a detention order, state in writing why they actually denied it. And allow victims of juvenile crime to apply to the Victims' Compensation Fund, which I don't know why this wasn't in place, but right now a victim of an adult crime in the adult court can apply to the victim fund, but victims of juvenile crime cannot. So I think that would be a really good thing. So the legislative session begins a couple weeks, February 7th. It ends May 8th. There is 92 days to our session. Buckle up. But there is hope, because election day is November 5. So I know I was not as entertaining as Andy, but I hope you learned something here today. So with that, if you have any questions.
I have a question.
Okay, where are we starting? You want to moderate this?
Yeah, sure.
Okay.
Let's start right there.
Hi.
Actually, let me start with Court.
Yeah.
Court, go ahead.
Two related questions. First is there a sense of what percent of those car thefts are gang related? And the second is I've lost count now, 3, 4, 5 of these street mob incidents where kids have taken over the streets. I don't have any sense of that getting better. And I think one of the things people need to consider about this is that these are kids who are using social media as a form of essentially flash mobs. So if you go back to Varsity 6, what's to stop the same mechanism being applied to these kids in a raising stores?
So when you say gang-related, I guess you're talking organized gang, because 5 kids getting together is essentially a gang, right? We do have a gang task force tied to the state police. We don't have stats as to what percentages. That's the best I can answer on that. The street takeover thing, a lot of people don't know. We did, in the waning hours of the legislative session, pass a law that is supposed to help with the street takeovers. I don't remember all of the elements, but one of the things we fought over, and actually some of the Democrats were helpful on this, is the organization of them. To actually be able to go after the organizers. So we made it a crime if you post on Facebook, hey guys, we're going to be taking over this street or this parking lot or this area. Posting that on Facebook is a crime under this new law. So we are very cognizant as to the street takeover situation.
Linda, you got a question?
Yes, I don't know if there's any mandatory psych evaluations for any level of the crimes.
No, there are no mandatory psych evaluations. I'll tell you, psych evaluations are expensive. first of all. You know, I don't know that, so let's just say that a psych eval comes back that somebody has addictive personality, right? I don't know that that necessarily helps, you know, where are you going to go with the juvenile justice information just because you have that? So I don't know that that is a remedy here, but you know, on average, in my experience, because I do a lot of family law, a psych eval costs about $10,000 to $12,000, and a good one. And I don't know that our economy can bear that cost, and I don't know that it would be really a value.
The follow-up to that is, it would apply to that 14, the progression thing, is what I was looking at. That if it was actually evaluated back a number of years ago, maybe it wouldn't have gotten this far.
Well, part of that's true. Part of the problem is, though, the age cutoffs. So, you know, just because you have an evaluation and, you know, this young man has a propensity to commit a crime again, you know, the law is driven by age, not by factors. So that wouldn't change, you know, whether or not the case is in juvenile court or adult court or that kind of stuff.
Thank you.
Okay, one more question right over there.
Thank you. More information to add to it. There was a question at the end of it. Being a nurse that's worked in the quietly spoken about homes, and I know you bounced on it real quick, but went over it real fast on the DCF part. These youthful offenders have nowhere to go. These youthful offenders are sexual crime offenders. They are aggressive assault offenders. And I'm going into these places years ago, and they are housed, whether you know it or not, in public houses in your communities. You may not even know 2 houses down has 4 of them. And that's the sad part about this. So I guess my question is, they're not brought to a facility like the one in Middletown where they should be brought on a highly, I'll give you an example. A 15-year-old boy, 16-year-old boy rapes maliciously his 5-year-old sister. Hurts her. She's scarred for the rest of her life. But she's 30 months, he's put into a private home with his own room, and he's fed, and he's got to school, and he's got transportation. And with that comes weekend passes. He is a sexual predator, a sexual offender. Weekend passes. This is what's happening with this, and they're not going to these facilities. So my question is, when is the state or anyone in the House going to bring up information into this proposals that why aren't you letting anyone in the neighborhoods know that these houses exist in their neighborhoods, next door to their daughters and sons, that the people can make a decision to go forward to their towns and go, wait a minute, we don't want that, which might force enough to open up those facilities again. So I'm just saying, do you see this happening? Is anyone going to bring that forward, that these are in private communities that they're not made aware of? And these people that are living in the communities with these homes where these offenders are going.
So that utilization is guided by the local planning and zoning regulations. So it's just like if somebody was running a manufacturing facility out of a residential area. If somebody knows that the utilization is not approved through the proper planning and zoning process, they would make a complaint to their zoning enforcement officer, who would be able to do something like a cease and desist or something.
If somebody's made aware. Otherwise, it's not spoken of that this home will not.
Well, then how do we know that it's happening if they're not aware? So, in the incident that it is happening, if there is concern, then, and I've had that in my community where there was a concern, and I had the individual call planning and zoning, and they learned that it was a permitted use in that particular neighborhood. So shifted the focus of the neighbor to say, well, maybe it's not, it shouldn't be a permitted use. And then started to ask their planning and zoning commission to modify the regulations to prohibit that. Now that utilization more than likely would be grandfathered in, but that's usually where I see that stuff going, so.
Okay, question on top of that one itself. So if they're actually committing sexual assaults as a juvenile, do they show up on the sex offender registry?
No.
They would show up on the sex offender.
They do currently, okay.
Well, if the court makes that a condition of their adjudication, while their conviction, while the case is pending, everyone is innocent until proven guilty. There is not a pre-trial registration of that.
All right, well, thank you very much, Craig. Craig Fishbein, state rep.